Greetings everyone, and welcome to this lightning talk on the evolving treatment of Internet Archive Wayback Machine evidence by U.S. federal courts. I'm Nicholas Taylor, and I'm presenting to you today in my capacity as an occasional expert witness on the same. I'll start by providing some context on the authentication and admissibility of Wayback Machine evidence in U.S. legal proceedings generally. The Wayback Machine is referenced in the dockets for at least 300 U.S. federal court cases. Notwithstanding the frequency of its use, evidence from the Wayback Machine faces a higher bar for authentication than other websites. I'll discuss in brief each of the four principal strategies for securing its admission. Judicial notice is a provision of the U.S. Federal Rules of Evidence that grants judges discretion to admit evidence that is so well known and authoritative as to not be subject to reasonable dispute. The standard affidavit is a template legal document provided by the Internet Archive that attests that attached printouts of content from the Wayback Machine are accurate copies of its records. A witness with personal knowledge of a historical website may attest under oath that archive web content is what it is claimed to be. An expert witness may explain the operation of the Wayback Machine and properly qualify what conclusions may be drawn from its contents. Having enumerated the principal strategies for the admission of Wayback Machine evidence, let's look at their relative success in the U.S. federal court's context. Judicial notice has been more successful than not and has been the most commonly utilized strategy. However, it has failed as a strategy the highest number of times relative to all other strategies at both the district and circuit court levels. Earlier this year, a ruling on consideration of judicial notice for Wayback Machine evidence was such a watershed that, unusually, the news reached the web archiving community. This wasn't the first time that a circuit court took up the question of judicial notice for Wayback Machine evidence. What was notable was that the judge undertook an extensive review of precedents from which they concluded that judicial notice of Wayback Machine evidence was inappropriate. As a circuit court, the ruling is to be treated as generally more precedential, particularly though not exclusively for district courts within the circuit. The expected impact would be for judicial notice to be a less successful strategy going forward. The Internet Archive standard affidavit is the second most utilized strategy. It appears here as though it has been only partially successful, but the two cases in which it failed had to do with misapplication. The affidavit has otherwise been a consistently reliable strategy. The third most common strategy is relying upon the testimony of a witness with personal knowledge of a historical website. This has had mixed performance both at the U.S. district and circuit court levels. Using an expert witness has been the least common strategy, but, like the Internet Archive standard affidavit, has served reliably for the admission of Wayback Machine evidence. Now I'll make a few quick observations about trends across U.S. federal court cases and a few standout rulings involving Wayback Machine evidence. In many of the cases, the Wayback Machine was actually introduced by the judge themselves, usually to provide additional context or to otherwise supplement the record. In many of the cases, the judge was predisposed towards the admission of Wayback Machine evidence, indicating that they'd only decline to do so if arguments were made as to why it shouldn't be admitted. In many of the cases, the converse was true. The judge was predisposed against the admission of Wayback Machine evidence, indicating that an affirmative argument had to be made as to why it should be admitted. In multiple, though fewer than many cases, the judge recognized the fact that many web pages in the Wayback Machine were incompletely archived but admitted the evidence anyway. Conversely, in multiple cases, the judge recognized this fact and noted it as a basis for denying admission of Wayback Machine evidence. In only one case so far, a party argued that Wayback Machine evidence wasn't reliable because of any of a number of different web crawlers might have captured a particular web page. In one case, a party argued that the Internet Archive staff member who prepared the affidavits, historically that has been the office manager, did not themselves run the crawls and therefore was not qualified to attest as to captured content. In one case, the judge demonstrated a specific understanding of web pages replayed in the Wayback Machine as temporal composites, noting that the relevant text was in the HTML. Having reviewed many cases, I'd say the main takeaway is that, with rare exception, legal professionals appear to have only a general understanding of the qualifications on Wayback Machine evidence. This unnuanced understanding is the shaky basis upon which judicial notice and the Internet Archive standard affidavit continue to enjoy success as admissibility strategies. If we would like for Wayback Machine evidence to continue to be regarded as trustworthy, it behooves us to continue to help educate the legal community on what in fact they're dealing with. I hope you'll consider what opportunities we may have to do that together. With that, I thank you for tuning in for this lightning talk. I hope that it's been informative. Please feel free to reach out to me if you have any questions through the contact information available on my website, noelhandel.org. Thanks.